So, folks, hello, I'm Steve Fenske. I'm one of the attorneys with MAT, and I was asked to give a discussion on selected topics of road maintenance, or how different laws affect township roads, and some really particular ideas. So this presentation is on those topics, and we're going to have to start some discussion of the year rules. So we have the 6-year rule, the 25-year rule, the 40-year rule. And those are kind of shorthand that we use to refer to some concepts that are important to townships. And I'll describe each of them in the statute and how they work and the changes. And then we have a couple other topics that were specifically asked for too. So while I'm doing this, I'm going to turn off my screen so you can just see the presentation. Okay. So what we've got to start, we're going to start with the low numbers and work our way up here. The 6-year law. The 6-year law is a way that townships gained right of way early on and really throughout township development. These roads are created because the township started maintaining them at some time, and the public used them. It maybe was that the landowners wanted a road and the town agreed to provide it, or there was just a need in the community for it, and so they started maintaining. Well, this law is written here, and this is the old version, okay? This is not the version you would go find today, but you need to know about this old version. I'll explain why. So it says, when any road or portion of a road has been used or kept in repair or worked for at least 6 years continuously as a public highway by a road authority, it shall be deemed dedicated to the public to the width of the actual use and be and remain until lawfully vacated a public highway, whether it has ever been established as a public highway or not. Then there's a line about cities that I removed because it doesn't pertain to us. This subdivision shall apply to all roads and streets except platted streets within cities. Okay, so broadly, that's the thing that created maybe a lot of your township roads. And in particular, if you can't find a recording on a road, like if you go to the county recorder and you can't find it anywhere, it's probably because it wasn't ever created in a formal way where you'd have something to go record at the recorder's office. And instead, you probably got it through this way. So we have 55,000 miles of town road in the state. I wouldn't be surprised if half or more were created by this thing, because it was just it creates public roads by need. It says, okay, township's been doing this. It's been investing public dollars, and it's been doing it for some amount of time. And here it said 6 consecutive years. Okay. Can be any 6 consecutive years. It could have been from 1900 to 1906. Okay. And if during that time the public used it, or it was at least open to the public, this statute says the township gets an easement. You didn't take it. Townships didn't, take the ownership of the land from the underlying owner. It's just that they were able to get this public easement that we use now for our town rights of way, and that are still used that way. And they may even look indistinguishable. If you just go look at them, it's indistinguishable from a recorded road, because within that space, you can do whatever you need to do. It mentions that it's to the actual width, okay, of maintenance. So that's a pretty important part. And what is maintenance? Okay. That's some obvious parts and maybe some parts that are less obvious. So what is maintenance? First, it's the activities on the road surface. Well, of course, the road surface is part of your road. That's the obvious part and the thing that everybody can just go see. But the less obvious part are the areas to the side that are used to support the road. So for example, if you have an inslope and an outslope, or just one of them, something that's defined to keep the road bed up and out of water, and it's part of that road structure, well, that becomes part of the actual use. That's part of what you maintain. And it would be included in, what is this road? What is this road created by the 6-year law? The thing that usually creates the most right of way is snow plowing, because the snow has to go somewhere. We don't truck it out, we push it to the side. And all of the area that we use to store snow where it gets thrown is considered part of our actual use as townships. We're using that part of the property to put the snow on so people can get on the road. Okay, so that distance may change depending on the road. How fast can the plow vehicle move? How far back has the plow been pushing snow? Okay, but in some cases, the plow vehicle can move pretty quick and the snow can be thrown really quite far. If that's the case, you may have a lot of right of way on a road created in this way. You'll notice I haven't said anything about 66 feet or that there's a defined right of way width. And it's because there isn't with these. That's why we're using these activities of our maintenance and the structures of maintenance to figure out how wide is this thing. That's the real challenge, because most people can agree, even when one of these things is challenged in some way and goes to a court, everyone can agree there's something there if the town's been maintaining it. Now, the road surface is the obvious part, but then towns may get into disputes about how wide is the right of way other than that, because landowners may want less right of way. Popular issue these days is access to lakes. If the right of way doesn't extend far enough, well, the public may lose a right of way access into the lake. So we've had these kind of challenges that commonly come up, and that's why we're looking at what are you doing on any one of these roads. Okay. To know if you even have to look at this stuff, the first step would be that you check the recorder's office and you check the county auditor's office to see if there is anything filed on a road. And if there's not, that's where we get into this kind of analysis where we say, well, what have you been doing and how long and when? And you detail all the things you do. So that's why I've got road surface, snow plowing, the inslope, outslope. You can add in, well, mowing and cutting. How wide has that been happening? And then water structure. So if you have culverts or you have ditching that you've done, that's all part of your maintenance too. Now flip that a little bit. Let's say it's a road that you haven't been plowing, which is potentially a big problem. Remember, there's no unplowed roads in townships. This will come as a surprise to many people, but there's no law that says you don't have to plow a road in the winter, or if it's minimum maintenance, you don't have to plow it. That's not the case. Okay. But let's say that has been the practice in your township. What it means is you may not have any more right of way than the actual width of that road. So when you're asked to go plow it and you suddenly have to, you may have a sudden trespass problem because you never took more right of way than the road width itself. And you haven't had the course of maintenance to claim enough right of way on the side. Okay. These are problematic for townships. They get into big disputes with landowners, in large part because landowners and um, mortgage companies that give money, title companies, surveyors, all those folks work on the presumption that anything that exists in property is recorded somewhere. And they may know that that's not entirely true. But if they can't find a recording, it's hard for some people to accept that, in fact, that thing exists. Okay. So one way that we address that is with this document. It's in our information library in the town roads section, TR 8000. I believe it's might be the last document in there. Town roads 8000. This document is intended to help you with this. And what you would need to do is you take a stretch of road, and this is where it's time consuming. You can't do it for all of your roads at once, but you take a road and you list the name or the number. Okay. And you list the date that you're doing this. And then on what you're going to do below is fill in these blanks. Okay. Length in feet, length in miles, width, all the stuff that you think is there. But what your maintenance staff should be expected to do is to, every time they do something on a road, they should pull out the form for that road, date it, and list what they did with enough specificity that somebody can come 20 years from now and see, oh, they mowed this. Here's what they did. And if they can estimate the width, maybe they know the width of the mower, which isn't too hard for them to know, right? As they maintain it, they can put mowed to this width, took trees to that width. Occasionally, what should be done is to estimate how far out the snow is being thrown. And that's not, you don't have to stop every 100 feet or something, but you get a general idea of how far is the snow going. And that's listed in the action items. Snow plowing, snow thrown out to how many feet from the shoulder, from the edge of the road surface. This kind of document, I think it's hard for folks to understand how important this document would be if we ever get into a dispute about a road. This thing can show your maintenance and how you've taken care of it, and show a judge what you did. It provides some clarity. It shows that at the time we were doing it, we recorded this stuff. It wasn't just made up when we needed it. So please, on any of the roads where you know there's might be a contest, start doing this now. On any other road that you can, it's a fair thing to expect somebody to fill in a date and a one-line description of what they did that day. And this can save your township a lot of money and a lot of hassle in fights with landowners. Okay, there's a new version of this law. I don't like the new version of this law, and I don't think you're going to either. The new version came out of a particular legislator's discussion with a constituent who was just upset with his township, and who said, well, basically, if that road had never been created by that 6-year rule, I wouldn't have had my problem. So the solution here had nothing to do with the problem. That's one issue with it. The other issue is that it's just simply not very practical. So I put the whole text here, and I don't want to read the whole text to you. Okay, it'll be on the slides. It's on the statute. The top part, part A, is what you already saw and what I read to you. The underlined parts are all of the new items in this statute. Okay, again, I'm not going to read it. Instead, I'm giving you this summary. Here's the changes. What this says is a township, to be able to create any new right-of-way with the 6-year law, you have to do some extra things. You're going to have to give notice to all of the owners of property sent by certified mail, describing what the township intends to do with that road, describing the road or its segment, like listing the name or the number of the road, and the time you expect it to be working on the road. You must include specific language from the statute, which in short says, hey, we're going to do work on your private road, and eventually we're going to take this from you without compensation. The big problem with this is it doesn't make any sense. One big problem with it. Townships don't go and do work on private roads in this way. The 6-year rule, that creates roads by consent. Basically, people needing a road or wanting a road. It serves a public purpose, and the township went and served that function with the expectation that that's going to be a public road. This flips it on its head and says, you as a township on a new piece of road or right of way, you could maintain it for 50 years. You could pave that road at township expense. And if you didn't send this notice, and you can't prove you sent the notice, the township and the public will never get the benefit of the work. They will not get protection under this statute. And I'm not confident you get protection under any other statute or common law method either. Maybe, but we'd have to go fight about it. Townships don't go onto private roads with the intention to fix them up and just for the convenience of the owner. That's not a public purpose. We're not allowed to do that. You may be thinking about plowing. Well, there's one instance in which you can plow private drives under contract and take payment, but that's not this situation. This is something else. And what it tells me is the lawmakers didn't really understand what they were doing when they made this. They didn't understand town roads, nor did they come and ask us. Okay. So the description you're going to have to give is that, hey, we're doing this work for you, and if you don't object, in 6 years, we take it from you, which leads to the possibility of, even if you send the notice, they accept your work for 5 years and then object, and your work is lost. You don't get to recover any money. Okay. Or if you don't send the notice or you don't get to all owners, maybe nothing you do is going to create new right away. So I say this as a caution. Beware of doing any work on something where you can't tell if it's already a town road, because you may not get the benefit of it. The public may not get the benefit of doing it. This is a law we're trying to change back. We're trying to show lawmakers, hey, this didn't make sense in the first place, and there's reasons for this law. And those are good reasons that created many of the roads you may drive on. Okay, so that's the 6-year rule. That's where we're creating, typically creating township roads. And you needed the old version because all of your old roads created under this thing before 2020 are still good. But you should document that in some way to explain, here's what you had before versus here's what's going to happen after 2020. The question is, what do we do with the forms? You don't record them. Those forms stay in the township records. I don't even know that the county recorder would accept it, but it's not a recorded instrument like that. If you wanted to do something that's a recording, we're going into separate areas or of statute, and something like this may be a basis to help you make that claim, but the form itself is not for that. The form itself is to show, here's our maintenance activity over time. So if we ever get in a dispute, we can show how we've been maintaining it and how wide we've been maintaining it. Then after a snowstorm, all roads covered need to be recorded on a township road history form. So Ken, the question there, it's not that you have to note that all of them got maintenance. You could, but the real issue is the width. And it would be a pretty easy way to just take your road forms, mark in the date on a snowstorm, at least some days to show here's the maintenance we've been doing. And in particular, if it's something like this, it shouldn't take too long. If it's being done electronically, which isn't, impossible these days, it's a matter of copy pasting across all those roads. So it's not meant to be a hindrance. And the work up front, you may be thinking this is a lot of paperwork and I don't want to deal with it. Well, it's a lot worse if you get a challenge from a landowner and you have to fight that. And not all challenges from landowners are covered by insurance. So you should be aware that your township may be spending money on something like this. Whereas if you just did the simple form, or your maintenance staff did the simple form as part of their job, so they're going to get paid, it would take care of that issue. Okay, 25-year law. We're increasing our number of years here. The 25-year law has taken special concern lately because of some cases going on. I'm not going to comment on any particular case that's open right now. One resource I'll point you to right away. I did a long article in the last Township Insider on the 25-year law that tried to explain it, how we understand it, how courts have understood it, and how it's a very powerful tool for townships. And I would go so far as to say now it's an essential tool because it, over time, allows township roads to go away and to be recognized that over time, some roads don't need to be public anymore, while still providing an access for people who are down that road. So here's the statute. This is a voter power. So this is that voter power statute 365.10. That's the list of things that the voters get to decide. And that's where this thing lives. This is a voter power. It says the electors may let the town board, by resolution, determine whether to open or maintain town roads or town cartways under the jurisdiction of the town board, upon which no maintenance or construction has been conducted for 25 years or more. Okay, that's the primary language. The next language is saying, hey, if this happens, people still get access to their property. So they may still be entitled to a cartway, for example, or something like that. It also says explicitly, that reference to 163.16, that's the impassable road statute. And that's where somebody who's upset about the condition of a road can go to the county and say, I'm angry and they should be maintaining this road. That phrase is saying, if it's been 25 years, an individual cannot go to the county and complain that that road is impassable and get relief under it. In other words, the legislature did its work well. This was in 1981 or 82, I believe, to say, if it's been 25 years, there's a spending limitation upon the township board. They do not get to just reopen a road just because they want to, if it's been that long. And I think it's because at that point, if you see a road or something like that, and it hasn't been touched for 25 years, I think most people would say, oh, that's abandoned. There's a common law notion of abandonment, and there's a whole book of law about a common law abandonment. This is different, but it follows the same underlying idea of it hasn't been touched for a long time. It's a little bit different from abandonment in that abandonment has elements of intent. Did you intend to abandon it? This doesn't have that. So instead it says it's not abandoned, it's not gone. But we recognize that there may no longer be a public interest, no public purpose in spending township money on that road. If it's been 25 years, can't we presume that the public doesn't care about that road? Isn't that a fair assessment? And it still allows the voters to come back at their annual meeting and say, well, town board, we're okay if you reopen that. You can spend our money on that. Okay. So it still provides that opportunity. But it understandably says if it's been 25 years or more, the board can't just go open it. Now, a landowner who has land down that road, they still get to use it. They may even maintain it themselves. But they don't get to just demand that the town improve that road or maintain that road. And some of these may be in good condition and maintenance may not be a big deal. Some of them are not in good condition. Some of them would require building a whole new road at public expense. So these are not inexpensive consequences here. Okay. This applies to all of a town road or part of a town road. And that was decided in a case about 2 years ago, about 20 months, 18 months ago, a township road case that we had. And the Court of Appeals considered it. And it was a situation in which I believe it was about a half-mile of road. The first quarter had been maintained for quite some time because somebody lived up to that point. But the second quarter had not been maintained in decades. Nobody had needed it. And there was a bridge along that second quarter. Bridges, as you know, are very expensive to replace. A new landowner came in and he wanted the town to maintain that road, that last quarter mile. And so he said, well, look, they have to do this. This is still a public road. And so it went through the court system. Ultimately, the court found, well, yes, it's still a public road. But this 25-year law is in effect because it's been decades since it had maintenance. And the voters have not allowed the town board to spend money. And even if they had, the town board still has to decide that it's appropriate to spend that money on this road, on this bridge. Okay. That case was, I will name a name here, Windermere Township versus Hagen, or Hagen v. Windermere Township, probably, as it were. But that one's a Court of Appeals case that really explained how that thing works and its features and functionality. And it also points out how important the voters are in that decision. Why give that question to the voters unless we're going to consider the public interest in something like that? So today, the law is if it's been 25 years and we haven't had maintenance, you don't touch it as a town. Okay. 40-year law. Marketable Title Act is what its real name is. This is a law that says we want to make sure that people who own property can actually buy and sell it without hindrance and question about clouds on their title and have to go to court and fight this stuff. So this is a super long statute. If you just read the parts of it, it's like hundreds of words without any period. I mean, it's insane. So what it comes down to is this: unrecorded interests in real property are void if possession is not shown in the property within the last 40 years. So unrecorded means it's not recorded in a county recorder's office. County auditor's office doesn't count. Okay, county recorder's office is what counts. A lot of town roads originally were filed in the auditor's office because that's what the statute said to do. And in the 70s, Supreme Court said, well, that doesn't count for this statute. And what it means is if you have a town road and there's not a recording in the recorder's office, if you haven't done maintenance on it for 40 years, then any other owner, anybody who has an actual title to that property, can claim that the town's road interest is void. It's gone. It's like it never existed. Okay. So this is intended to be used defensively by some owner who's contesting title, and it's sometimes used against the townships since the 1976 decision. In that case, that was Sterling Township was the case name. So if you have a road that you haven't touched in a long time, and it hasn't been 40 years, one thing is to check the recorder's office again. If there's a recording, this law does not apply. Again, if there is a recording on the road for your township, you go to the recorder's office and there's the road order. This law does not apply. Okay, it's not effective because it's only for unrecorded interests in property. Now, for all those things that are not recorded, like all those 6-year roads that we talked about earlier, well, if that's how you got your road, this 40-year law does apply. And you want to pay attention to that, in particular, if you want to keep that right of way. If you don't want to keep that right of way, that's fine. You can let it die by this Marketable Title Act. What does possession mean? Possession means enough activity to put people in the world on notice that someone has a claim to this thing. So if you're doing road maintenance, and that's what it would be for a township on a town road, our possession is shown by our maintenance. So if you're plowing it, you're resurfacing it, putting gravel on it, you're doing the maintenance on the side of the roads, all this stuff, that tells the world we have an interest in this thing and we are continuing our interest in this thing. Okay. Each of these concepts, they overlap. Okay. One road could have been created by the 6-year law and then could be subject to the 25-year law if it hasn't gotten maintenance. And then at 40 years, it could go away. That could happen to a single road. But when we consider these, it's most helpful not to try and intermingle them. Okay. Because for one thing, the 6-year law is about road creation. The 40-year law is about losing a road, removing a road. It's not apples to apples. Likewise, the 25-year law isn't about creation or vacating. It's about spending limitations. So these are confusing. We know that, we realize that. We step through these questions about road status in that kind of step-by-step manner. How'd you create it? And that's a 6-year question, might be part of the question. Are you still maintaining it? And that's part of the 25-year question. And then did you lose it or vacate it? And that's part of the 40-year question. So these are different steps in a process with any road. So try not to consolidate them in your mind or make sense of them as a group of 3 here. These are different concepts posing different questions when we look at these things. Okay. All right. The last thing I believe here is I got a particular question. What happens with access at the end of a road? You have a road that leads to a body of water and it dead ends at the body of water. Well, does the public have access to that water? And the short answer is yes, they do. The townships I mentioned before, they don't usually have a true ownership over property that roads sit on. They're not the fee owners, as it's called. So like if you own your home or land, you're probably the fee owner, most likely. You are the owner of that property. Underlying any other interests, you're the owner. You may owe money to financiers or something like this, mortgage companies, but ultimately, if you satisfy obligations, it's yours. Okay. Townships don't have that for roads. They have an easement. And it's pretty well established law that you don't have to have fee ownership, meaning that true ownership, to have access to water. And that's what riparian rights are. So my first mention here is a recent case that dealt with this question. It was a city case, but the concepts are the same because it's access to water. That doesn't depend versus what local government it is. So the court, and part of it says, where dedicated land, like your township easement, ends at a body of water, the dedication includes riparian rights to that water. Riparian rights are a person's or a right holder's ability to use the water surface, and to have access to it. So that's just code for access to water. Riparian rights is access to water. That case, Schussler case, was about a city. They had a fire lane dedicated to them in the late 1800s. This is just for fire truck access, basically. But it wasn't a road. It wasn't developed into a normal road. It was just used as this fire lane. And the dedication sat there for a long time and eventually probably became irrelevant as a fire purpose. It led to the water, Lake Minnetonka. There's a lot of interest in getting access to Lake Minnetonka. So the city wanted to put a dock there. And the neighbors objected, saying, well, that you have a fire lane, you don't have riparian rights with your fire lane. And the court determined that no, in fact, this fire lane, even though it was dedicated for a different purpose, it ends at the water, meaning that the city has rights to access and use the water, access to the surface of the water. But that is shared riparian rights with the neighbors. So where that easement sits over top of somebody else's property, like our township roads, and then it ends at water or runs along water, it means that the two share rights to the water. They both have access to it, and neither is allowed to prohibit the other's access unless it's by legal means. So like ordinances or something like this related to a person's access to water may be respected. Okay. But where it's shared, the town couldn't do something that prevents the neighbor from accessing the water or enjoying their property. And these are done on a case-by-case basis. So there's not an obvious answer always, because some of the question that can arise is, okay, township, your road dead ends at the water or runs to the water. The public has the right to access it. But what does that mean as far as how much access? What can the town do with that access? So I posed some questions here. So the dock at the end of the road. Well, that one seems pretty well answered, probably by that Schussler case. It wasn't definitively answered there because one of the claims is that, well, the neighbors say, hey, the city's activity is impeding our rights to use our riparian access to the water. So yeah, we're supposed to share it, but they overstepped their use of their rights. That's the claim. So that's why I still have a question mark. A dock at the end of the road? I don't know. It depends on the circumstances. What's the neighbor's use? How much land do they have? Where are they situated? Do they need that part of the access, or do they have other access? At the road at the end of the road at the end of the waterway, excuse me, the water at the end of the road, flip that around. Chances are the neighbors, they have more property that touches the water and have exclusive access from that part. There's less likely to be a disagreement or interference, but they still may claim there is because they don't want the public there. Okay, where the road runs parallel or along with the road or along with the waterway. Now we may have more confusion or discussion about what it is, because the entirety of the road is sitting on all of the riparian fee property that the neighbor has, because it's which way the road is oriented, if that makes sense. Okay, so the circumstance can change the answer here. So the dock at the end of the road, I don't know, probably okay. What about parking? Well, if it's within the right of way, arguably people can park at the right of way, but it's also possible that that gets to a point that does interfere with another person's use and enjoyment of their own property. And it may not be allowed to have dozens of cars, whereas a few cars may not interfere with their ability to use their property. Okay. Park structures or picnic area. We're not talking about actually having a park. We're talking about within the right of way at the end of the road. We're going to make the road end a little short, and we're going to, move an access over a little bit. And we're going to put a pavilion, and we're going to put a picnic table. That's less likely than the other two to be acceptable. It still might be, because it's case by case, but that's a little bit different use of a road at right of way. That's looking like that's not just for transportation purposes. That might be for an expanded purpose, and that might lead to different impacts on the neighbors. So the basics here are, yeah, your township and the public have some rights when your road touches the water, but you still have to figure out the boundaries of that and how that's going to work with the neighbors. So, all right, I see a few questions. So I'm going to end the presentation here real quick, and I'll do this. My questions are blurry on one screen because I guess that screen doesn't work. Okay. When a road is posted limited access road, how does this apply? I don't know what that means. I don't know what a limited access road is. If the road is open, traffic can go on it. It's supposed to be passable to the type of traffic that could use it. So think of a car using it. I used to drive a little Volkswagen Jetta. I loved that car. It was great. I didn't take it off-roading, but on a town road, I should still be able to pass on a town road in most circumstances. Not terrible blizzard and things like this, but if it's an open road, it should be maintained to let it be passable. Not grand, not great necessarily, but passable. Okay. Limited access, I'm not sure what that means for you guys. If a road has not been maintained for 25 years, the electors at the annual meeting pass a resolution to allow maintenance. How long is it in effect? There is no statement in the law about how long it is in effect. I don't think that's answered anywhere in law or in a court. So a township could take the approach that it's a standing authorization. I think that would get stale at some point. It should probably be put back to the voters at some point to figure out or to reauthorize that. And because the board has the choice, they can always say, hey, look, we think it's been too long. We're interested in doing this, but we want the voters to say it's okay. And that's acceptable if it's been that amount of time, because the voters can, the board can point to the fact that, hey, there's been a long intervention of time here. Our status financially may have changed. The board itself may have changed. The intended use of the property has changed. And there's a lot of factors that can go into that. I'd say within a year, you're probably fine. 2 years, you might be fine if you're showing that you're considering it, planning it, looking at it, negotiating or something like that. If it takes 3 years to change the board's opinion, I would think that's too far. That's too long. That has to be redone. Just my personal opinion. Again, that's not in law, but at a certain point, that's pretty stale as a voter decision. Not to say a town board could decide, well, we're going to go with it and see what happens. Okay, that might be when you refer to the town attorney and get that person's input on it. All right. What can a township do if landowners place electric fences, non-running vehicles, or other personal items in the roadway? Okay, well, if stuff's in the right-of-way itself, there's a statute that lets you remove it, and it's actually a crime. So that statute's 160.2715, 160.2715, and it says it's a misdemeanor to do, I think, 13 different things in the right of way, and leaving stuff in the right of way is one of them. So you'd probably just call them first and say, hey, this thing's in our right of way. Did you know that? And oh, I didn't know that. And they'll probably say, okay, well, we need you to move it. And then you can get into discussions with them. If they refuse, you may take some self-help measures and push it back over the right of way line. Okay. Or maybe if there's a fence and you can't do that, you bring it to them, and that has a cost. You may also work with the county sheriff, who can ticket them. And some county attorneys will help, not all. But remember, this isn't a township ordinance that needs to be enforced. That's what some counties will say to you. Well, that's a township problem. I don't do that. You know what? They enforce all kinds of laws within the township that are state statute. This is a state statute. It's not a local ordinance. And this is just as much their duty to address as drunk driving on a township road or something like that. No different. Okay. So they can help with that. Fences are a little bit difficult, because if you take them down and no livestock is running, you have a bit of a problem. You may need the help of the town attorney to compel that person to do something. Okay. You also have special assessment powers, remember, which can have the work done and you charge their taxes, whether they like it or not. So those are some opportunities too. All right. I think that's all the questions I got. Kristen,
Penny, did you want to unmute?
Oh, there we go.
Ask a question? I just saw the hand was raised. Oh, go ahead.
That was a total mistake, but I do have a question.
Okay.
In our township, our town roads, we have a maintenance agreement with the county, and they come in and do all the snow plowing. Do they keep records? Because I don't think we do.
I doubt it, unless you're asking me to keep records. Probably not.
So the counties don't do that kind of record keeping for the county.
I don't think so. You'd have to ask them. But county roads aren't generally created by that 6-year law. This is something that townships rely on greatly. Other governments could rely on them. But nowadays, cities and counties, they record all their roads. And counties and the state, they have fee ownership of their roads a lot of times.
Okay. All right.
So they're in a different position than you are.
Okay.
Let's show one other thing here. One other thing that's really useful. And people have seen this, I'm sure, over time. But another way to go back to that 6-year thing and try and document what you did is to use aerial photography. The county may have some really good stuff for you, but otherwise Google Earth has really good stuff for you. It's available online. Okay. There's also a better version though for you for this. You can download the desktop version to a computer. When you load that, there's an option to view images from the past. And we've had cases, like court cases, where the attorneys use this to show here was the state of the road in 1970 and 1985. And it shows very well how much of it was plowed and where the right-of-way line was and how things work. And you can see over time how it changes. That can be a really useful item on something like this to show what was it in the past. So these are pretty remarkable tools available freely. You know, I'm not sure which township we're in here. It will tell you if you select the right things, but and the online version doesn't do the historical photos, at least from what I can tell. Okay, the desktop version does. So, all right, any other questions? I work for County Highway Department. They document on their time card for each road that's plowed. That's good. Yep. So they do that. Counties do that. It sounds like, or at least this county does, Hubbard County. So it's not probably something terrible to ask if they can, or if they can share that in some way. And the other cool thing is this is going to become more automated, I believe. Trucking is already automated tracking of where they went and how fast they went and all this stuff. Well, our vehicles are going to come to be capable of that too, including your maintenance vehicles. And so I think we will get to a point where this is going to be automatically logged of where they were, and that's a piece of the information. It may not show what they did while they were there, but it's something to help show. Here's where that plow truck was at this time, and what does a plow truck do in January? It plows stuff. You know, that this can help the system too. So thank you, Christina, for that. Anything else? Kristen, am I the last of the day here?
Yep, this is now Q&A time in the
Q&A
agenda.
time. Okay, for us, for Lori, for Penny.
And you know, there were a couple people who tried to do Township Tuesday this morning, but since we were hosting this call, that was not available. So I know Sherry and people at the Met office were getting calls. They say, how come we're not having Township Tuesday? So sorry about that. It was in the monthly newsletter.
Yeah, I'm sorry about that. I almost thought maybe we should just do it anyway, but we didn't want to interfere with this event. So sorry, folks who did that. So question and answer time, I guess, Town Tuesday. For those who don't know, Town Tuesday is something we run every first and third Tuesday of the month, except this month right now, where we give updates on whatever has happened over the last couple of weeks. We give reminders. We tell you what's new, what has changed, things going on at MAT, the events, and we also have a question time. So Carl and I are usually on. Carl's been on them a lot lately. He's been taking them and doing a great job with them. And then Lori, as well as just on staff clerk trainer available here. So so we've had that available to folks. So question and answer time, anything about topics today or unrelated to topics today? And while you're typing or getting ready to raise your hand, remember we will, for all of them we can, we'll produce the slides in a version you can print. Some of them will have more handouts and sample documents you may be able to use. That'll be on the webpage. There's also one more day tomorrow, aimed at clerks and treasurers, but remember anybody can attend these if you're a township officer.
Looked like
Thank
John had
you.
hand raised. Oh,
I was just gonna say, we're getting thank yous. Thank you folks for attending and nice messages.
I see this. Cheryl, go ahead. You can unmute. If you want.
I think those are the space bar. If you're muted, it'll unmute too. Yes, I think it was temporarily unmuting. So if you have a space bar, you can do that too. Hold it while you talk.
Or maybe there's a microphone problem. I can't hear you, Cheryl,
Could be
but
too.
it does look like you're unmuted.
So the kind of reminder you would have got at Town Tuesday this morning is with our elections, we're coming to, today will be the first day for those who canvass their result on Town Tuesday, on, excuse me, on election day last week. You canvassed then. Today should be the last day, I believe, of the contest period. So tomorrow, certificates of election could be given and folks can take their oaths. Remember, even if you've done that before, if you were on the ballot and you won, you got to get the new certificate and take the oath again. Even though that seems redundant, make sure you take the oath every time you enter office.
I have another announcement from Jeff that just came in. There's a treasury webinar on Monday about ARPA reporting. So I will post this in the chat and it will come out in the monthly newsletter too.
Any other questions? It's the quietest group of 199 people we've ever had.
Oh yeah,
Yeah,
because it's a webinar.
that could be.
I still can't hear you, Cheryl. I know your hand's raised. Maybe you could type in the chat. Or send us an email. Call. Question from Travis. What was the desktop version with map history?
If you do Google Earth, you can just use a search engine and search for Google Earth, and it'll try to let you do the on your web browser login. But there's Google Earth Pro, which is free to download, and it's for your machine. It's not going to run in Firefox or Chrome or Edge. It'll run on its own application. So that's the thing that you want to look for. Google Earth Pro download, and you should be able to download that, install it, and then play around with how that thing works. And there's different layers. There's a really powerful tool, but one of them is historical maps. All right. Well, it looks like we have answered everything we can, and we try to answer Cheryl, but we're not getting through with Cheryl here. So thanks everybody for joining us. We're happy to see so many join us today. Again, we'll have the recordings and everything up. If you have questions based on what we've presented, please send those in. Be patient with us as we tend to get a lot of them at this time of year. Oh, go ahead, Cheryl.
Yep, we'll call you later.
Oh,
Okay.
that works. That's just fine.
Oh, can you
Like
get
I
me
said,
now?
that's the thing to do.
Yeah.
Call us or send us an email, and
Okay.
Carl and I and Lori
Okay,
will
being
get
that
back
got
to
me
you.
now,
Sure.
what the question is, we have a male supervisor on our board and the rest are all females. And he's passing rumors, and it's that we, the women, are the hen house group of AIDS or chicken house group AIDS. Is there anything we can do about it?
Politically, you can vote him out of office, and that's not probably a satisfying short-term answer. With elected officials, there's not a lot you can do with something like that. If it's interfering with someone's access to government services, that might be a different story. But chances are it's just going to cause harm to the township, and you won't necessarily be able to get that person removed. So as you pointed out, there's a gossip, there's a bullying question there. There's it's certainly not kind or respectful as a workplace, and that's what they should be looking at it as, not just as a political entity where the elected officials can do whatever they want because they happen to not have a consequence. So there's not a lot there other than to minimize that person speaking, which you can do. The majority sets who the chairperson is, for example. Okay, and there's not supposed to be communication between board meetings anyway because of the open meeting law. And running the agenda pretty tight, you can minimize how much discussion there is, an opportunity for that while you're with each other. You, of course, can't really control what that person does or says outside of the meeting. except to point it out to people like this. You raise the awareness of this is what's being said. It's inappropriate. It doesn't help us move forward. I don't know how he's expecting to have us agree with him or even consider his ideas if this is how he's going to work with us. So politically, it's kind of doesn't make any sense for him to act that way, I guess.
Okay, thank you.
Mhm.
Oh, we have Jack. Can unmute Jack.
Sure, I'll add if you do have employees, remember, it doesn't even have to be the person or persons at whom the conduct is directed. If an employee were present and felt uncomfortable, that's as much of a problem for that employee. That's now an employment problem that they'll have to deal with too.
Jack, you can go ahead. Unless it's the microphone problem again, I can't hear anything.
As we're having so many technical difficulties, I think we're going to halt it there. And folks,
Ready to
call us
go.
with your questions. Remember, that's what your membership is. Call us. We'll help you. We'll talk to you. We can probably have fuller and freer discussion in that private setting than we can in this meeting anyway. So again, thank you everybody for logging in. Come tomorrow if you can, if you want. We're really happy to see you guys here. We're even more excited at the prospect of seeing you guys in person the next time we can do an in-person event, something like that. So, all right.